Hey guys, this is Scott Horne of Horne Associates PC. And this video, we're going to take a minute and just talk about, can a lawyer help you save a deal that's going on for some reason out there? So if you like it, please take a minute and like the video. Make any comments as we go through. We'll do our best to get back to you on those. Hope you join us on our YouTube channel as well. I'm actually going to use paperwork that I rarely do, just because I wrote some things down just to go through all this along the way. Just some maybe top 10 things that I came up with on this topic. Typically you do not need lawyers in a real estate transaction, at least not in a standard residential deal. They're too easy. Your closing agent, your lender, you yourself as the investor, you probably just don't need one. There's a time and place occasionally, I get it, but for the most part you don't. You flop over to commercial deals, there's almost always lawyers handle the deals from start to finish. And even the escrow officer does very little along the way. But there is a time and place for things where lawyers can help based on the situation. So one of them here I came up with was, you have an LLC, but the wrong person signs. In a corporate scenario, if it's a corporation, it has to be an officer or a director to sign. If it's a LLC, it needs to be a member or a manager to sign. Well, what if somebody else just signs? Well, I had that happen just the other day, and it was a realtor who signed for a seller. And it's like, yeah, time out. No, you can't just do that. This is an individual, not a corporate scenario. To do that, to validate the contract, you need a power of attorney if you want it to be a valid contract. If it's a corporation, you need a valid corporate consent where the entity is giving you the authority to sign on their behalf. Either of those two ways works, but just signing and saying, well, I'm the realtor, that doesn't work. And so if you have the wrong person signing, you're going to go back and re-sign it. You can't, unless that person is elected or you get that corporate consent that the attorney can help you with, along the way. Sometimes in the real estate world, we see where the chain of title gets broken. Maybe there's an endorsement of the note or assigning from company A to company B to company C. Well, company C says they own it, but it's missing the assignment in the middle from company A to company C. And company C, of course, says they're the holder, they're issuing a payoff maybe, but there's no evidence that they're the actual holder of that mortgage. Okay, I can see in those cases where the attorney can step in, help to navigate the endorsements, maybe contact some old lenders, bring that forward along the way. And sometimes they're able to get more activity on that than maybe the escrow officer is in that scenario. Well, what if there is a deed of trust? And again, this happens in the mortgage world, and it really happened going back to the real estate crash world in the subprime days, where everything seemed to get lost. There's a deed of trust, and the deed of trust, the assignment of that deed of trust, just like an endorsement in the note, wasn't recorded. Where lender A sold or transferred the loan to lender B, but there's no evidence of it, other than the fact that maybe the seller's been paying that lender all along, they have mortgage statements, etc. But in the legal chain of title, that's missing. Sometimes there are resolutions to those kind of items, sometimes they're not, and you've got to figure out just how do you fix that. And oftentimes a standard escrow officer is going to have too big of an issue to deal with that. What about property taxes? Somehow out there, these escrow companies, title companies, they'll provide what's called a net sheet to a seller. This is what we think you're going to net in the transaction. But what about delinquent property taxes? And they get missed. Does the seller still owe those? Absolutely. What about rollback taxes? That is where someone passes away. That person who died and owned the property at that time, they may have had multiple exemptions. Maybe it was a over 65, over 70 exemption. Maybe it was a military disablement exemption or something of that nature, where the taxes are either greatly diminished or none at all possibly. But that person may have died several years ago, but the heirs of the estate never notified the taxing authority of the change, because when that person dies, the exemptions go away and it probably gets retaxed at its normal value based on who now owns the property. You've got to do this. And whenever we see that, in our offices at least, it's like, stop. Any probate, any issue, look at the taxes, the tax cert. Are exemptions attached? If they are, pull it forward and collect everything, and always err on the side of caution. But it's getting sellers to understand these kind of situations, that it's their problem, their fault. They've got to do what they got to pay it. And when they get hit with these big numbers, it's not a good day, guys. And sometimes the attorney can help with that to a certain degree in negotiating with the taxing authority, but negotiating with taxing authorities is almost a never winning prospect. You know, another thing that you can think about where the attorney can be helpful is in having a conversation about what a balloon payment is. Oftentimes, if a buyer is out there and they've negotiated with their lender a balloon, you'd hope that they already knew what that is when they negotiated it. But sometimes they just don't understand that, you know, when that balloon comes due, whether it's a 1-year balloon, 5-year balloon, 10-year balloon, the entire principal balance in the loan, whatever that principal balance is due. And it's not that you get the chance to redo it again or modify it unless your lender agrees to it. It is due. And again, that's where the attorney can help to explain things to that buyer more appropriately. Keep in mind, guys, in the title world, an escrow officer isn't allowed to provide legal advice to the seller or the buyer. Even though they may have the knowledge base to do so, that's a no-no in the insurance world. That's where the lawyers step in to handle those kind of conversations to help a seller or a buyer understand what the ramifications are of that in case those things pop up. Oftentimes, the lawyer becomes very handy in a creative finance type transaction. Now, what if it's a subject to deal or a wraparound mortgage? Okay, you need to make sure all the parties understand those terms and conditions. And again, the escrow officer cannot explain what due on sale is or what the ramifications of that are, about seller liability that continues, or what's a wraparound and how does that work, and who's going to pay the first lien holder, etc. That's not the closing agent's job, and they're not going to step over those bounds. It becomes the attorney's job if it has one. So you'll find that, at least in our offices, even though there may be title insurance involved, we still close those deals in our law firm. We obtain the title insurance for our buyer and or seller. But because we're lawyers, we can take the time to explain to the seller and the buyer the situation, what's going on, how things are working, because we have the authority and the ability to do that, unlike the escrow officer does. You know, there are times that a lawyer who's a good real estate attorney comes into play is when there might be survey issues. You know, normally on a survey that's for a residential home, there's not too many issues unless you're out in the country and you have meets and bounds and various things going on. Because typically it's a pretty straightforward survey. If there is an encroachment, the fence is over, you know, as we say in the surveying world, maybe a tenth, about that much. It's not a big deal. But what if someone built their garage over the property line? That's a big deal. You might need a property line agreement between, you know, lot number 1 and lot number 2 to handle things appropriately. Or there's a carport and the top of the carport is overhanging. There's all types of scenarios like that can happen. It's also learning how to look at a survey, understanding what the easements are that might be on there, whether it's a utility easement that's underground, maybe it's an overground aerial line easement, maybe it's a big transmission line easement. Rarely will you see pipeline easements and those kind of things running under residential properties. It's going to be usually in the commercial world. But you want the attorney to be able to review that and make sure it's proper and correct, as opposed to the escrow officer. And they're the ones who can help solve those problems fairly quickly, because sometimes you could have a situation that could just kill a deal that comes out of the survey. Is it a shared driveway? Well, whose responsibility is it to maintain that driveway? If there's nothing in writing, maybe you need that property line agreement, as I said earlier, to lay out some of those dynamics that an attorney is going to have to handle for you along the way. So I can see those being issues, and especially when you get into the commercial world where you have larger tracts of land, you have all types of issues to be dealt with, just from easements and other items of that nature that a buyer may want to review with it. Usually the buyers or the seller's attorneys are going to handle those direct, but if it's you as the buyer, you may want to make sure you have a survey and a lawyer who's familiar with that review it for you as well. What do you do when there are estate issues? And this is so common, especially in the investment world, where someone's passed away. We talked about rollback taxes. Number one, you got to look at those. That's very important. But two, it's making sure, do we do what's called a affidavit of heirship? Maybe. Some states do that, some don't. Do you need to file probate each and every time? Again, some states require that, some don't. Are there shortcuts to probate? Such as here in Texas, it's a muniment of title or evidence of title, where a will is basically acting as evidence of conveyance of ownership to somebody. For instance, maybe there are 4 brothers and sisters, but a will leaves a certain property to one heir. Well, if you only do the heirship affidavit, all 4 heirs get 25% of that one property. And so the heir who is named in the will may want to utilize that as a muniment of title, which is a quick, less expensive probate mechanism, so that they get 100% of that property. Each deal is a little bit different to look at, but again, this is where the attorney comes in handy to help explain the options to the seller and or the buyer along the way, so to help them navigate the transaction appropriately and what might be best for them. And again, these are things that an escrow officer just can't do and shouldn't do, and it's things that the investor who's not a licensed attorney do either. So there is a time and place, I think, where attorneys can be beneficial in our closings, even residential closings along the way based on certain circumstances. Basically, they're there to draft the basic documents, the deed of trust, the warranty deed, those kind of items for you, maybe some basic probate docs. They don't normally need to get involved too heavily in these things. Every once in a while, though, they do, and you want to make sure you have the right lawyer there who can take care of those things, give you the good answers you need without having to stop, go research it, and come back to the table. So guys, I hope you found the video helpful. If you did, take a minute and like it, give us your comments, come see us on our YouTube channel, and I always say, we'll see you guys next time.